conference is being recorded.
I think everybody should have heard that, saying that this conference is being recorded. So at this point, I'm going to go ahead and start the session. I'll do another intro, and we'll get going. Good morning. I want to welcome you to the fourth in a series of webinars that we're doing this spring and early summer on succession planning for small business owners. Today's session is structuring a sale of your business to an employee stock ownership plan. And today's speaker is Carl Grassi. He's with the firm McDonald Hopkins, which is a law firm here in Greater Cleveland. And Carl is one of the preeminent ESOP attorneys, not only in the state but in the country. And we're very pleased to have him here with us today. And so I think without further ado, I'll turn it over to you, Carl.
Thanks, Chris. Thank you for this opportunity. My topic today is structuring a sale of your business to an employee stock ownership plan. And we'll be focusing on transactions, really the leveraged ESOP transaction. And leveraged basically means that there's some sort of debt or other financing that's being used to accomplish the transaction. It doesn't have to be that way. There are many ESOP transactions that are not leveraged, but our focus today will be on the leveraged ESOP transaction. In terms of a leveraged ESOP transaction, there are a number of things to consider on the overall general outline of one, and we'll go through a diagram in a moment. First, the basics are that an employer establishes an ESOP. An ESOP is a qualified retirement plan, no different than any other qualified retirement plans that a company might have as a 401k or a profit-sharing plan. But the difference being that an ESOP is established to primarily hold employer stock. So it's not one where there's other investments or other alternatives. Its goal is to primarily hold employer stock. The technique that a leverage transaction typically takes is the ESOP borrows from a lender the proceeds necessary ultimately to buy shares of the company stock from a selling shareholder or from the company. It does that in a number of different ways. Many times a newly established ESOP doesn't have any proceeds in its account, so it seeks to borrow those dollars from another party. Most often it's the employer of the company. It's the company itself that it borrows the dollars from. Sometimes, however, it can be borrowed from others, including financial institutions, the selling shareholders, or whomever. The ESOP basically uses those proceeds of the loan to purchase the employer securities. Because there's a loan in place in terms of the ESOP borrowing proceeds from some source to buy those securities are held in what's called a suspense account in the ESOP as security for that loan. As time goes, and then naturally what happens is those proceeds then are used to buy the stock, obviously, of the selling shareholder, and then the account is held as those shares are held in suspense account as previously mentioned. The employer, in this context, somehow that loan has to be paid off over time. What typically is the case is the employer makes tax-deductible contributions, no different than any other type of pension contribution that would be paid, subject to certain limitations that I'll address later, to the ESOP, and then the ESOP in turn takes those proceeds and repays the loan. As payments are being made on that loan, securities that are held in that suspense account are basically allocated to the individual accounts of the participants based on an ESOP allocation formula. Typically, a common formula is compensation. One's compensation over total eligible compensation, and that ratio or that fraction is used to what shares are released in a given year based on the principal payments that are made on that loan. This diagram here was a real-life example. It was one where an ESOP was formed by a company to basically accomplish certain succession planning objectives. In this illustration, you'll see there's 4 individuals, A, B, C, and D. A was the largest single stockholder in this company. B, C, and D were relatives of A, but A was basically, in terms of age, he was the senior of the B, C, and D, and he desired to create a liquidity event for his shares. But as you would note, in the context of this transaction, it was only A that was interested in the liquidity event. B, C, and D were looking to continue to own and operate the business. So selling to a third party and selling a minority interest, less than 50%, was an unlikely event. The buy-sell agreements that A, B, C, and D had in place only required on death a buyout of A's shares. There was no obligation otherwise. There were certainly rights of first refusal, that if A sought to sell his shares to a third party, B, C, and D had a right to buy those shares under the same terms and conditions, but no obligation, if you would, for A to put his shares to B, C, or D, or the company for that matter, to accomplish the transaction. The ESOP was an alternative that was considered and ultimately implemented for a variety of reasons. One of which, in this deal, there was A had a fair amount of insurance on his life that the company was paying for the event when it would occur, when A would pass away and the shares would need to be bought out. That cost was significant. In addition, there was a compensation that A was being paid over the years that also would be eliminated if A was no longer needed as a shareholder. No longer a shareholder, his services as chairman and CEO of the company would succeed to be in this case. And that was really one of the things that, in this context of this transaction, it was important, because in the context of setting up a company to buy out A, or setting up an ESOP to buy out A, the important component for B in particular was the ability then to succeed to being the chairman and CEO of this company, and having that occur in lieu of, obviously, the death at some point of A, which there was obviously no one knew when that would actually occur. So we talked about an ESOP. We talked about the benefits and the considerations, which we'll go through today a little bit. But the decision was made to form an ESOP. So if you look in the transaction, company in numeral 1 formed an employee stock ownership trust plan. And that plan basically was formed for the purpose of buying out A shares. In the next step in the transaction, the company borrowed money from its outside lender. The company gave a note to that lender. It received the cash. And then it lent that cash to the ESOP in numeral 3 in exchange for a note. The terms of those two notes were substantially similar but not identical. And we can explain a little later why that wasn't the case. But it was really to provide the company and the ESOP more flexibility as to the timing of paying off that inside loan between the company and the ESOP versus the outside loan between the company and the lender. The proceeds were then received by the ESOP. ESOP had an independent appraisal that was done to determine what was the fair value of the shares being purchased from A, and purchased those shares at that point in time. In the context of this transaction, the company was a C corporation, and we'll talk a little later about the benefits of deferral, if you would, to the selling shareholder in the event of a 1042 transaction, if you would, which is commonly called, when stock is sold to an ESOP where the ESOP owns at least 30% of that company at the end of the day, and the benefits that the A could realize in that event. As the transaction moved forward, let's say the next period, the exhibit you just saw was the Exhibit 1 was kind of the formation of the company and the underlying transaction. Exhibit 2 kind of reflects what happens as the loan is paid off. And in this situation, the company, as I mentioned previously, makes tax-deductible contributions to the ESOP, which are subject to limitation. And then in turn, the ESOP uses those dollars to repay the company on the loan that the company provided. And then ultimately, the company basically used those same dollars to repay the lender. So there's only one set of dollars, but this is more of an accounting entry that's occurring to allow the deductibility of the principal, in effect, the principal payments that are made to the lender, not only the interest payments that were made, but in essence the principal payments as well. But it's through the vehicle of pension contribution, if you would, from the company to the ESOP. The next exhibit shows this benefit to the selling shareholder. As I mentioned, this was a C corporation. So in the context of this transaction, if the ESOP immediately after the transaction owns at least 30% of the company on a fully diluted basis, then the selling shareholder has the ability to elect what's referred to as 1042 treatment, and basically the gain that would otherwise be realized on the transaction of selling his or her shares to the ESOP can be deferred, and potentially can be deferred permanently. To do that, the selling shareholder takes those proceeds that he receives in this sale of his shares and has to buy what's referred to as qualified replacement securities. Qualified replacement securities are dollars that basically are corporate stocks and corporate bonds. They are publicly traded corporations. And when those bonds or those shares are ultimately sold, is when the gain would otherwise be realized in the original transaction. In the event that they're held till death and the current estate tax law is still in place, in fact, the income tax element is permanently escaped, and the stock that the replacement securities step up the fair market value, and that gain that would have otherwise was deferred is permanent in terms of not paying taxes on it. That's based on current tax law, but that obviously is subject to change based on any legislation going forward that would be enacted.
Carl, quick question.
Yes.
What do you foresee as the likelihood of that being changed?
I think there's a very real possibility that the deferral, the income deferral, will be recognized on a death event. And so I think that has the potential to go away. I think ESOPs in general, there is some concern out there because of the administration and frankly Treasury looking at ESOPs overall and viewing them as a potential tax loophole and the benefits that we'll talk about here. So there is a concern in the ESOP community that the current state of ESOPs, while they may continue going forward, there will be some curtailment of some of these benefits and advantages, including, if you would, this 1042 deferral.
Okay, great. Thank you.
Mm-hmm. The repayment of both the principal and interest, as I mentioned, in a C corporation setting, the company is able, by the pension contribution, is able to deduct, if you would, each year a payment is ultimately made by the company to the ESOP in the form of a pension contribution, creates the deduction that the ESOP in turn repays the company with on the loan, and those proceeds then go out ultimately to the lender, whoever that lender may be. It could be the selling shareholder, a bank, or other party. What's misleading oftentimes, and you'll hear from people in the that are aware of ESOPs but may not understand the complete mechanics, you oftentimes hear that someone will say that if I do an ESOP transaction, if I structure it properly, not only will I be able to deduct the interest on the bank debt that I incurred to set this ESOP up, but I can also deduct the principal payments. That is technically not correct. That may be the effect, but that's technically not correct. The deduction is occurring because the company is making a contribution to the ESOP in an amount that equals that cannot exceed more than 25% of eligible compensation, and those in any given year, plus interest, that is then used to repay on the ESOP debt by the ESOP to the company. That's the technical way it occurs. As I mentioned to you earlier, though, years ago it was very common to have a situation where ESOPs, the terms of the outside loan with the bank or other institution or other lender, and the inside loan between the company and ESOP were identical. And they were identical for a couple of reasons. There was a provision in the tax law a number of years ago that allowed that if the ESOP owned at least 50% of the company after the transaction closed, then the bank would be eligible to exclude 50% of the interest income that it would realize from the repayment on that note plus interest on the outside loan from being taxable to the company, to the bank. That oftentimes resulted in better rates that the bank would offer to the company in exchange for that loan. The key element, though, is the outside loan and the inside loan had to be identical. That provision is no longer applicable except for some very old grandfathered loans that were in existence when that provision was in place. So as a result of that, to have the effect that your principal payments are being deducted, you need to basically make the payment from the company in the form of a pension contribution to the ESOP, in turn pay it back to the company, and the company in turn pays it to the lender. But oftentimes companies don't need that much of a deduction in the early year, or may have a year where economically they don't need that size of a tax deduction. So the common approach today is that if your outside loan with your bank is call it a 5-year loan with a 10-year amortization on principal, it's not unusual to have a loan between the inside loan between the company and ESOP possibly being a 15-year loan and paying principal payments evenly during that 15-year period. So there's a mismatch as to what's being deducted, because remember, it's the pension contribution that's being paid down to that ESOP that's creating the deduction. So if the ESOP doesn't need to, it only pays 1/15 of that principal payment as opposed to 1/10 that's being paid by the company to the bank on a 5-year loan with a 10-year amortization, then the payment that the ESOP receives in the form of a pension contribution may be smaller, therefore the deduction is smaller. and can be turned around and handled that way. Now, on the other hand, if the company had a very significant year that year and needs a larger deduction, as long as it doesn't fall outside the 25% limitation rules, it could make a larger pension contribution to that ESOP, and the ESOP in turn can prepay on some of that note back to the company, and the company can use that to satisfy the loan, so to the lender. That is a more common technique today than what's being done in the past. Another technique to create deductions is the use of dividends. In a C corporation, if a company pays a dividend on stock and the dividend paid on the stock is held in the ESOP or used to repay the principal and interest on the loan, then the dividend is deductible. Now, the issue that you have here is that the IRS is empowered to deny deductions if the IRS determines that the dividend constitutes substance or avoidance or evasion of tax. And where do you usually fall into those issues? Well, you usually fall into those issues where the dividend is deemed to be some sort of an extraordinary dividend payment, a very large sum that really doesn't really reflect a true dividend being paid on a company stock, but something else. In those cases, there is the risk that the IRS could come in and determine that the dividend was excessive and therefore deny a deduction for the excess over what would be considered a reasonable dividend. And in context of these situations, when companies are having their outside appraisers involved in terms of the ESOP and the annual valuations, and even when the company is looking or contemplating the need to pay a substantial dividend because the 25% limitation it may have may not be enough to cover the underlying principal payments that are due on the inside loan, and it declares a dividend, it should take caution to make sure that it doesn't run afoul of this rule or risk. It may want to seek out an advisor to let them know that based on comparable companies and the percent of the dividend, it's reasonable under the circumstances. Going back to the 1042 technique and transaction, there's a little more detail here. Is that, as I said, only in a C corporation sense, not in an S corporation. And the difference between an S and a C corporation is in a C corporation, the company itself pays the taxes on its own income. In an S corporation, the income is passed through to the participants, and the participants pay the tax on the S corporation's taxable income. In the context of a C corporation, we have this ability to do what's, again, referred to as a 1042 deferral. The key on a 1042 transaction, first and foremost, is the shares that the selling shareholder is selling to the ESOP, they must have held them for at least 3 years. And in addition, they could not have received those shares as part of a compensatory event. If those two conditions are met, and those shares are ultimately then sold to the ESOP, and the ESOP owns at least 30% of the outstanding stock of the company after the transaction, then the shareholder has the ability to elect that the proceeds they receive to purchase qualified replacement securities within a period. And the period basically begins 3 months before the ESOP transaction and ends 12 months after, and buying what we referred to earlier as these qualified replacement securities. The rules defining qualified replacement securities are complex, but in general they apply to stocks of most publicly traded large corporations, which generally meet certain requirements, domestic operating type companies. Note that mutual funds and tax-exempt bonds are not qualified replacement securities. And sometimes that without the proper advisor providing that understands the 1042 deferral rules, or money managers that may be assisting a client or a selling shareholder, it's very, very imperative to understand that. Beyond the discussion of today's call, but there are techniques to buy certain long-term bonds or corporate rate floaters that may have a term of 30 or more years that cannot be redeemed by the company that's issuing those bonds. Those are oftentimes used in ESOP transactions because it defers, recall, when the underlying replacement securities are sold or in a bond case redeemed, that triggers the original gain on the transaction involving the ESOP. So many individuals are looking for ways to control that. Certainly in qualified replacement securities of stock, it's their decision whether or not they want to sell those securities. Whatever shares they sell, it's only those shares that have been that percentage that represents of the overall gain. So if an individual bought $1 million, sold his company for $1 million to an ESOP, sold his shares to an ESOP for $1 million, and the $1 million they bought 10 different companies at $100,000 a slug, and one of the companies they decided to, of corporate publicly traded stock, one of those companies, they decided to sell that position of $100,000 then it's only on that portion of the gain that was deferred that is now recognized, not on the balance of the other shares they continue to hold. So they in essence have control. But in a bond situation, oftentimes you can't control the event where those bonds could be redeemed and trigger that event. Thereby, there's these what's referred to as ESOP bonds, corporate rate floaters, where the interest rate resets over a period of weeks, days, months, that will be used to prevent, if you would, a redemption that a company would do without and triggering this gain. So that's a technique, but that's really for another topic or another discussion. In terms of an ESOP, the basic rules are the participants in an ESOP are basically the employees of the company. And all of them, because it's a qualified plan, have a right to participate in the shares that the ESOP holds as the loan is paid off by the ESOP to the company, and those shares are released to the participants' accounts. All of them have a right to participate in it. There is a certain limitation, however, on restricted accruals involving certain individuals that are not eligible to participate in those accruals only and if the underlying transaction, the selling shareholder, made the decision to take 1042 deferral treatment. So on those shares that the ESOP holds, more than a 25% shareholder of the company is not able to receive an allocation. The selling shareholder is not able to receive an allocation. And the selling shareholder's spouse, brothers, sisters, any lineal descendants are also prohibited from receiving an allocation. Now, in the event that the selling shareholder elects not to take advantage of 1042, and we're seeing more and more of that with the current low capital gains rates, then these rules do not apply in the context of a C corporation ESOP transaction. The accrual, depending on the situation, if it's a more than 25% shareholder, it's a permanent restriction. As to the others, there's a 10-year holding period, if you would, that they're prohibited from participating. One of the most important things involved in doing these transactions is that many times the participants, when a selling shareholder hears of an ESOP or a potential selling shareholder, they oftentimes are well aware of the tax advantages to the selling shareholder. And they may be loosely aware of the benefits to the corporation, the ability, if you would, in effect, to be able to deduct the principal payments on the debt in addition to the interest. Those are the key selling points that oftentimes it's one of the last true tax-advantaged financing vehicles that's, in effect, the government is assisting in the buyout process because of the very favorable tax consequences to the company, to the selling shareholders, which, as I mentioned previously, may be under risk or attack based on the current legislative initiatives and some of the concerns going forward on any new legislation that would curtail some of those benefits. Oftentimes what's overlooked and not fairly considered up front is that at some point when these participants vest in their shares and they leave employment, and in the context of a closely held business, they're going to be looking for a liquidity event. Taking shares, a small number of shares of a privately held company with no market for those shares has very little value to them. They may have a value from an annual appraisal basis, but the value really is predicated on the fact that they have an ability at some point to put those shares back to the company when they should leave employment, and the company then being obligated to buy back those shares at the then fair market value. The key issue here is the company needs to have the cash to fund the repurchase of those shares. In addition, there is a requirement by law that when a participant turns age 55 and has been in the plan for at least 10 years, they have the ability to diversify what's held in their account. Recall that in an ESOP, the primary asset they have in their account is the company stock. Well, after reaching age 55 and having 10 years in the plan, they have the right to diversify up to 20%, and then when they turn 60, another 25%. Well, as we remember that an ESOP, since it only holds primarily holds only company stock, and sometimes it does oftentimes have cash in the account as well, it has to seek the cash from somewhere. So either there's cash in the ESOP that was previously contributed by the company that sat in the ESOP, or there was other assets that were in the ESOP because when the transaction was originally done, there was another profit-sharing plan or 401k that was merged into that ESOP. But there's going to be a need for cash in any event. And so the other piece that's many times overlooked by companies in looking at this and the ultimate repurchase liability is not only what's the age of my workforce, what's my turnover of my workforce, when do I expect, based on that, how do we want to set up the vesting schedules on these accounts, how do we want to release these shares to these account holders, ultimately what's it going to mean for us going out that we're going to need in terms of cash to fund that obligation. The one piece that many times is overlooked is this diversification requirement, that when a participant reaches the age of 55, has more than 10 years of service in the plan, they have the ability to seek diversification. And the failure to plan for these events up front in the very beginning when the document is being drafted, other corporate governance issues that need to be considered, oftentimes results in a situation where down the road the company is faced with this obligation and its only avenue may be to sell the company to satisfy that obligation. On the other hand, where a company takes the time and the effort up front to design its plan for the eventual, and it's not only the likelihood, it will occur when their employees begin to reach the age of diversification or when they begin to relieve employment, that they begin to address those issues up front with some sort of funding mechanism for that eventual obligation. It's those companies that you'll see oftentimes be generational in scope, and the ESOP will go through not only the generation that was there when the ESOP was put in place, but multiple generations thereafter. And this is a very, very important element. And it's one of those, kind of like an estate plan of an individual has, is every year when an ESOP in place, it's prudent to revisit your repurchase obligation. It's basically an actuarial computation to see where you stand and how you're funding for that and what necessary steps need to be taken. The cost of establishing and maintaining an ESOP, there is a certain cost to doing this. And the cost, as you could imagine, initially it's the transaction forming the plan, the trust, if you would. It would also be the lender. The accounting side of these transactions are different. The statement of position 93-6 under the accounting rules is now it's been codified into another section, but the old line is SOP 93-6, tells you how you have to treat ESOPs when you form them from a balance sheet and income perspective. In addition, so you need to have very qualified accountants that understand ESOPs. You need to have qualified lawyers who understand putting these in place, the nuances that you need to address. Every year there's an independent appraisal that the ESOP has to engage someone to conduct to value those privately held shares. There will be actuarial computations. There are a number of things that result in the fact that the cost of establishing and maintaining an ESOP it can be meaningful. And depending on the size of your company, you may be able to do an initial transaction with all the bells and whistles for something in the $50,000 range, but it can run up to several $100,000 depending on the size of the company, and then the ongoing maintenance. So invariably, when you're putting an ESOP in place, you have to balance those costs against the benefits that are being derived. And in some cases, it may not be prudent, if you would, or cost-effective, if you would, to put this type of arrangement in place because of the costs that are incurred to do that. And you usually see this in a situation where you're much smaller companies, lower employee count, and you have to evaluate. But nonetheless, you should evaluate it and make a determination if it's something that works for your company for a lot of different reasons.
Carl,
yes.
What's the rule of thumb on the size of company, whether it be
Well, I can speak to my experience has been that usually when you see a situation where you're under 30 employees, it becomes difficult. It becomes a challenge for a lot of various reasons that dealing with the limitations on the deductibility, the pension contributions, and the like. It also depends on the size of the ESOP debt that you're looking to incur. If you're a company that usually where the issue becomes more problematic is if the ESOP debt is less than $1 million and you're doing all of this to put this transaction in place, you've got to start to evaluate what percentage of the transaction is being paid out for professional fees on an ongoing basis. So my rule of thumb has usually been employers with less than 30 employees and an ESOP debt of less than $1 million. These types of transactions need to be looked at very closely as to the cost-benefit analysis.
Great, thank you.
Mm-hmm. Another situation where ESOPs are a business succession planning tool, and they In some cases, as I mentioned, there are generational ESOPs that have been in place. The culture really fits employee ownership. In other cases, ESOPs are a tool that's being used ultimately to create another succession planning event down the road. There have been transactions where we've put ESOPs in place, and it was a father, senior generation looking to sell, and the next generation not having the wherewithal to do that. An ESOP was used as a vehicle. The ESOP was in place for a few years, and then ultimately, at some point in time, it was decided at that point in time that that next generation, for many reasons, felt that it was important to terminate that ESOP and for the benefit of the participants, and then take ownership with it and take over ownership. So it really does vary what an ESOP is used for. That's a common technique, but the issue that you have to be recognize is that at the end of the day, an ESOP is put in place, and the ESOP trustee's duty is to the plan participants, not to the management team, not to the other shareholders, but what's in the best interest of the plan participants. And if an ESOP is put in place and it is used as a vehicle in an abusive situation not to take that into account, then that's where you can run into some fiduciary risk by the company, certainly by the trustees that were looking out for the interest of the ESOP and solely had to look for their best interest. But I will say to you that even in the transactions where an ESOP might be eventually terminated or frozen, many of those situations, the circumstances at that time made it make sense to do that. And today what we're seeing a little bit is some senior companies and some mature ESOPs where the ESOP itself, the employees, a large percentage of their retirement dollars are in effect tied up in company stock. Companies are reevaluating that, and they're evaluating, is that really prudent? That an employee is not only, if something should happen to this company, not only is his job at risk, but his underlying investments in company stock, where most of his pension dollars are tied up in. Does that make sense? So we're seeing more and more in that context that it's better to, on behalf of the participants, to begin to create greater diversification. One way to do that, or one thing to consider, is terminating the ESOP at that point in time, or having some of the ESOP shares bought back by the company for cash or to a third party to begin to create more diversification on the benefit of the plan participants. So it doesn't have to be, and it should never be, because they're looking to abuse the benefits of an ESOP. In fact, if you try to do an event within 3 years of formation of the ESOP, there's certain penalties and excise taxes that the company is liable for. So it's something that needs to be considered and thought out carefully. And once again, on this slide here, I'm looking at the whole point again, that it's used as in the example I gave you in the diagram. We had that A shareholder who was 35% owner and looked at wanting to retire and get out. There was no vehicle, if you would, to create a liquidity event, and the ESOP provides the founder with basically buys those shares from that individual, and structured in such a way that the management and really the governance remain in place and no real changes. The other benefit with an ESOP is it helps where you have, once again, an illustration I provided earlier, A, B, C, and D. Well, where that company is today is A sold to the ESOP. Now B retired a couple years ago. He sold to the ESOP. And now it's down to C and D. So the ESOP can be used very naturally as that succession plan to ultimately have, at the end of the day, potentially a 100% employee-owned corporation, and use that going forward to benefit the employees. I can tell you that I've seen many successful ESOPs where the participants in the ESOP are retiring with 7-figure plus in their account of company stock, and then ultimately having that stock bought out. If structured well, and if you have the culture that really fits employee ownership, doesn't mean that they have a right to see financial statements, doesn't mean that they can tell the management team how to do their job. But if you foster a culture where employee ownership is important, meaning you have greater control over stock of a company you're employed by as to its value than stock of a publicly traded company that you have not a meaningful ownership interest in. And as a result of that, many times ESOP-owned companies have performed better than non-ESOP companies because the employees feel they have a stake in the business, and an ESOP can be used for that vehicle. Any questions at all? That's kind of the essence of the program, but I wanted to give you an overview, and if anybody has any questions, feel free to ask them.
I want to feel free to let the participants know they can unmute their phones if they have some questions that they want to ask. I'll pause here briefly to see if that's the case.
Carl, this is Mel. I'm curious as to your feeling on Treasury really taking away the 1042 benefit.
Well, I think there's a real risk, as I said previously. Treasury. First of all, we'll start from a couple perspectives. The Department of Labor is not a big fan of ESOPs,
right.
And over the years there was bipartisan support for ESOPs. Today, there is really no champion in Congress that has come forward yet to champion the benefits of ESOPs. And there have been numerous articles written over the years. One I recall specifically, must have been 5-6 years ago, it was the front page of the New York Times talking about this great benefit that you could basically sell your stock, not recognize the gain, and realize these underlying benefits in these qualified replacement securities. I think there's a real risk that this will be one that will be curtailed, and I know that the other real risk that we're seeing is these, which we didn't really spend time talking about, is S corporation ESOPs and the benefits of being derived there. But obviously some of the bad press that's come out on the Tribune deal, right, where many people felt that that transaction was really pushing the envelope as to what you can do with an ESOP, completely legitimate. But naturally, when the company fell into bankruptcy, many are out there saying this was abusive in the context of ESOP transactions and what they were intended. So I think that's a real concern. I do think that some of the legislation that's been proposed, some in terms of the budget, where they're talking about certain stock sales of small companies, if they're newly issued shares, not having any income tax or any gain or loss. I think it's productive to see that because in many ways an ESOP is similar to that. But I think the big challenge right now for these companies is really the overall ESOPs themselves, and naturally this 1042 deferral. There were some issues going on in the 1042 area as to these corporate rate floaters or the ESOP bonds, and some people concerned that they were very similar to these auction rate securities. And so I think there's a real risk that this deferral may not be there. And frankly, I think we can all expect that capital gains rates are going to go up at some point. That would ultimately make the deferral much more attractive, again, because up till now a lot of people have said, I don't want to go through the hassle, I'd rather just pay my 15% capital gains rate and go on. So that's my view.
Okay, thank you.
Carl,
yes.
You chose the word curtailed, and I'm assuming that you chose it carefully because being a lawyer and such, so you don't see it necessarily going away per se, or just limited in some sort.
I think that the genie's out of the bottle, and I think the problem with trying to stuff it back in the bottle creates a lot of different issues. And if you look at past legislation, and one area you could look fairly recently is the S corp arena, where ESOPs back in 1998 were permitted an ESOP was permitted to hold stock in an S corporation. You recall back then there were a lot of one employee or single participant plans that were put in place to basically shelter 100% of the entity's income. And then there were rules that came in place that viewed that as abusive, and these anti-abuse rules cut back on some of those benefits. I see that kind of going forward. I see some further curtailment, if you would, of some of these advantages as opposed to blowing up ESOPs. I think that would be bad, and I don't think that's ultimately where it will go.
Okay, great. Thank you. Are there any other questions? I want to remind everyone that this recording will be available up on our website if you want to go back and revisit it. Excellent presentation from Carl. I want to thank Carl for coming out and doing the presentation. As you can see, there's Carl's contact information. If you have any further questions or need assistance in maybe setting up an ESOP, you can call Carl. As I mentioned at the beginning, he's one of the best in the business. So we're pleased to have him here today, and I encourage folks to take advantage of Carl's services. I think without further ado, I will remind everyone that we have another webinar coming up on Friday. This one's going to be on trusts and various ways to set up these kind of legal documents to transfer assets. So I encourage you to come out for that. We'll have an additional 3 sessions out next week. All that information is available up on our website, www.kent.edu/OEOC/SPP is where you can find it. And I think without further ado, I'll say thanks and have a good day.
Thank you, Chris. Thank you all.